The following presentation explains a huge problem concerning an out-of-control federal government welfare program called child support. This presentation will provide a simple solution to that problem. Child support has grown like a cancer in every state across the United States, now doing the opposite of its intended purpose. It was designed to reduce the cost of welfare paid by the government to single moms when the fathers were absent and not involved, but is now increasing costs dramatically. It also claims to help children, but in reality, the federal and state child support bureaucracies have become harmful to children, primarily using this program to undermine the father-child relationship. The child support problem is so out of control, it is begging for a solution, and I have a great solution. This video describes 1. The history and evolution of the federal child support program. 2. Why it is referred to as Title 4D. 3. How this program impacts state child support laws and policies. 4. The congressional purpose of the 4D program, explaining why child support is not for children and never was intended for children. 5. How the program has expanded far beyond congressional intent. 4D services were never meant for involved fathers who willingly provide the basic needs for their children. 6. The problems that arise with this 4D child support program on both a federal and state level. It is the only welfare program with no income eligibility standards. Because of this, anyone and everyone who applies is granted the whole range of collection services. This has become incredibly harmful to children and an enormous waste and abuse of taxpayer money. 7. To conclude, I explain an easy solution as a first step by creating income eligibility standards for government child support services where none exist today. While this presentation was given in 2005, it is still completely relevant today. I encourage you to watch the entire 1-hour presentation to educate yourself about the basics of this program. This is information the Child Support Agency will never tell you, but you need to know if you want to be part of any meaningful reform.
Today's topic is Title 4D Welfare Services. I'm going to answer 2 questions in the next hour and a half, and those questions are, first of all, does the federal government allow the state to initiate reform and clarify eligibility standards for Title 4D welfare services? The second question, will state legislators be assured the state won't lose the entire federal funding for 4A and 4D as the state DHS alleges? As we go through those 2 questions, the first question, I will review the outline listed here. We'll review family law versus welfare law, public rights versus private rights, the history and purpose of 4D as it is in the Social Security Act, the limitations of Title IV, Title 4D amendments, the unauthorized expansion of the 4D program, outcomes that produces regarding process and fiscal outcomes, and then we'll talk about the constitutional violations created as a result of that overreach. The second question I'll review and outline that will answer and describe for you the CPR solution, what the DHS claims, what the misrepresentative federal penalties are, what they look like, the positive impact that change and reform would have on government budgets, and also, hopefully, we'll have some time to discuss some fiscally responsible decisions that we can work with together. I want to begin with a disclaimer and make sure that you know that I am not an attorney and nothing I say today should be in any way, shape, or form considered legal advice. Though we have run through all of our information by our advisory board attorneys, several people who were able to work with and give us that legal input. I have also received information from 3 judges, 2 retired district court judges in Minnesota, 1 retired appeals court judge in Minnesota that believes that our information is accurate, and we continue to expand that base of interested judges and lawyers, although I found that retired judges are more willing to talk to us. The first question, does the federal government allow the state to initiate reform and clarify eligibility standards for 4D welfare services? The first subject in that area is family law versus welfare law. At the legislature, you've heard a smorgasbord of family law issues. There's child support legislation that Senator Neville has done an incredible job working with, which mostly focuses on the guidelines, whether it's a net income, income shares, cost shares, whatever it is. Then there's been legislation on joint physical custody. There's been legislation repeatedly year after move-aways, and really many other family law related issues, things as like OFPs, parenting plans, imputed income, a host of different topics that affect family law or that are part of family law. And last but not least on this list, of course, is Title 4D welfare reform. And I put this slide up here on purpose to show you that Title 4D welfare reform is different. It's something separate from all of these other issues, so it does not need to be in conflict or worrisome with any of the other legislation that we do also get involved in. I want to begin by saying also that we at CPR believe that both parents have an equal duty to support their children. And nothing that we are promoting or nothing that we are suggesting in Title 4D reform will at all impact that philosophy that both parents do have an equal duty to support their children. Title 4D is the child support enforcement and collection program put together by the federal government. So it's a federal program that's state supervised and county implemented. You're familiar with those kinds of programs. The Title 4D welfare program causes some problems or causes some myths. It's based on some presumptions that carry through the whole implementation of 4D, which causes concerns for us, and I'll go through a few of them here. The Title 4D system is premised on the assumption that moms have custody, and I'll go through later why that is. The 4D system is based on the belief that women are unable to self-sustain. The 4D system is based on the myth that dads don't want to parent and are only minimally involved with their children. And the 4D system is contingent on the fact that one parent is labeled an absent parent. The 4D system is based on the erroneous belief that dads won't support their children unless they're forced to pay. In fact, in the early 1970s, when they were looking at the 4D program for the first time, the National Organization of Women testified before Congress regarding why these child support laws were needed. And they testified saying that because they were getting, just by default, having custody of all these children, they made it clear to Congress that their views at that time were custody of the children to the mother is not an award, it's a sentence. That's why they created the 4D program at the federal government, to try to rescue these women from the burden of custody. The other premises or myths or basis of the 4D system include those that are on here. What it does and the problems it creates is it builds a huge bureaucracy that supports one parent at the expense of the other. It gives the custodial parent a sense of invulnerability because they have this whole bureaucracy on their side. It creates increased animosity between parents, pitting one against the other, driving a further wedge because you've got that whole system that's constantly initiating actions that the custodial parent hasn't even initiated themselves. This creates a deeper conflict, and conflict is what's worse on kids. Conflict is worse on kids than divorce itself. And the 4D system then is based on the concept that the custodial parent will get everything because remember, and you'll learn as we go through the presentation, that the assumption is the dad's not around. The 4D system, because it provides all these things for the custodial mom, provides everything for the custodial mom, and I say mom or dad, if I say those words erroneously through my presentation, there are non-custodial moms and there are custodial dads, but sometimes I slip up and use gender-based language, mom and dad, and that's only because, according to the University of Minnesota, 90% of the divorces and paternity cases in Minnesota result in custodial mom. So forgive me if I use those a little too loosely at times. The 4D system, probably the worst thing, and why there's so much of an uproar on this, is the sense of fairness is absent in the 4D system because the power of equities are not used in administrative law. And all these proceedings are done in administrative hearing process. The next section is public rights versus private rights. I just want to review that by saying that there's two different kinds of law. There's public rights and private rights. Public rights where there's a government interest, and private rights where there's no government interest. If one company, one small mom and pop shop is suing another because somebody slipped on their sidewalk or whatever, it's going to be all handled in private law. The government's not going to be involved in that. And there's also, with regard to the difference between public rights and private rights, I'm sure I don't need to review this for you because you're legislators and you're here and you know all this, but in private rights, everybody's protected by the Constitution. And in public rights, everything is statute driven. And in public rights, when the government is involved, there's always a compelling state interest. There's always a protectable interest by the government, a pecuniary interest, a safety interest, an interest for the general welfare. But the general welfare has limitations according to the law. And on the far right-hand side there, private domestic relations has been left up to the states. The federal government, according to the Constitution, does not get involved. And here is a report from the Congressional Research Service out of Washington that says, under the U.S. Constitution, Congress has little direct authority to legislate in domestic relations and family law issues. That's the private matters. And that's clear the way our Minnesota statutes are written. In chapters 245 through 267, it's all about public welfare when the government is involved. In chapters 517 through 519, the revisor's office has labeled those chapters in the statute as private domestic relations. The problem is that in our state law right now, we've run into a problem between mixing public and private rights. We've got the public welfare in the 256 chapters, and we've got private domestic relations law, which started out in the 518 chapter. Now we've suddenly taken what was meant to be public law, which the Title 4D law, and we've embedded it into 518, so we've blurred those lines. We've crossed that bright line of separating public versus private rights, which is causing a lot of confusion. Public rights and private rights, when it comes to family law, become very different. In private rights, you get a judicial proceeding in front of a district court judge. In the 4D process, you only get an administrative hearing in front of a magistrate. And by the way, the 4D magistrates in the administrative process are all paid for by the pool of money that is developed through the child support collections money that's put through the system. We'll get to that more later. In the judicial proceeding, the judge can rely on his equitable powers. In the public rights in the 4D system, in the administrative process, the magistrate has no authority to rule on their equitable powers. Everything is statutory only. No constitutional issues can be heard in that court. They can only be heard in the judicial proceedings. And what's most disheartening for many people that end up in the administrative process is according to the expedited rules in the state of Minnesota, hearsay is allowed. So there's a lot of families that are impacted in incredible ways based on hearsay, which that's where this sense of unfairness comes into play. So how did this all start? Where did 4D come from? 4D is from the Social Security Act. The Social Security Act was started in 1935, and we have a team of researchers. We've got 7 people on our research team that have researched Title 4D for a cumulative 38 years when we add all of our time together. So we've spent the time trying to understand this to figure out what has happened. Well, the Social Security Act was started for the purpose of providing a social safety net for low-income people. It was to take care of those that were dependent members of the population, and dependent meant dependent on the government because they could not take care of themselves due to poverty. So it was a way, the Social Security Act is a way of protecting those people, as we have learned, on a temporary basis for a period of time in their life when they can't do it themselves. The way the federal government decided to eliminate the major causes of dependency was to start out with the following sections of the Social Security Act. One was the Old Age Security, which we most all think about when we think of Social Security Act. Second, they started unemployment right away. They started the security for children right away, and they started a public health segment and a couple more as well. But the whole idea was to provide marginal, temporary, but regular income for individuals in need. So when I talk about Title 4D being part of the Social Security Act, we're not talking about affecting the old age retirement program at all. It's two separate programs. Right now there's 21 titles in the Social Security Act, and what we're talking about is Title IV of the Social Security Act. That is, Title IV, which is the rubric for that is needy families and child welfare. I can tell you exactly what that says, but that's the focus for Title IV. So Title 4D is a segment of Title IV of the Social Security Act. Title 4D is child support collections and enforcement, to give you kind of a picture of how this all fits in. So what are the limitations of the Title 4D Welfare Service Program? Well, as our researchers went back and studied this, not only back to 1935, but we've been back to 1912 to try to understand the whole evolution of these programs. Title IV was created by the federal government, and it was for a limited class of people, for needy and dependent people, to ensure their basic needs. And then we've got lots of references on how the whole Title IV is limited to those in need and those who are dependent on the government. Sometimes that word dependent gets confused when we talk about dependent children, because people think of dependent children as anybody 18 and under. But that's not true for Title IV of the Social Security Act. We're talking about dependent children, dependent who have no parents to provide for them, no relative to provide for them. So here you can see the legislative history here where it's limited to need independence. Here's another reference from legislative history of the Social Security Act, talking again about needy, dependent children. That was the appropriation for Title IV. So then we need to look at two different words, needy and dependent. What are those? According to a private independent report going back to 1946, as they were studying the Social Security Act, they made it clear in that report, and many others I might add, that need was defined by a strict definition. That definition in Minnesota law was clear in 1937, that a dependent child not only was under the age of 18, but was deprived of parental support because of continued absence from the phone from the primary wage earner, and not or not just, or not eliminating, but and whose relatives, nobody's relatives, no one is able to provide for them without public assistance. That's the purpose of Title IV. So that dependent child, here again, in Minnesota statute even today, where they're not able to provide for the child. In 1974, the federal government looked at Title IV-A of the Social Security Act. Now, Title IV-A is the section for TANF, Temporary Assistance for Needy Families, or AFDC was the old title for that. And in Minnesota, that's where the MFIP would come from, where all of the laws and all of the funding for MFIP come from Title IV-A. So in 1974, which was right after the sexual revolution, the federal government was looking at their Title IV-A rolls and saying, wait a minute, we have so many people on here, this is exploding. We're giving so much assistance to so many, this is unsustainable. So the federal government decided to do a study on Title IV-A to say, who are these people? Who's getting these services? What they discovered is the majority of the people in Title IV-A getting what we know of as welfare services were a result of out-of-wedlock births, single moms with children, dads were nowhere to be found, dads abandoned the family, all moms had custody by default because dads weren't there, dads failed to provide financially, they weren't around, and therefore mothers and children had been abandoned to public assistance. What they found out later is the only way the moms could get public assistance was if the dad wasn't there. So a lot of the dads, when they used to knock on the doors and say, hey, we're just checking up on you, the dads were actually up in the attic or hiding in the closet, so they weren't really even absent. So a lot of these assumptions that they've made to build the program on must also be questioned. So what they decided to do, the federal government said, aha, we have all of these people on 4A welfare services, and the dads out there, they should be paying. The dad should be paying. So they started the Title IV-D system in 1974 based on the following assumptions: that women cannot get work outside of the home, that women are expected to stay home with kids, that women are unable to self-sustain without assistance of the government or a man, that the men are always the primary wage earner, that dads do not participate, and all married dads are deadbeats. Those were the assumptions on which Title IV-D was built. And I think today we can see that most all of those presumptions must be questioned, so it must be questioned how the evolution of this program has gone even far beyond that. So this is where we're at, Title IV-D of the Social Security Act. In 1974, when they developed the program, then they developed it for two reasons, the federal government, for two reasons and two reasons only. One, to protect those single mothers with kids on welfare and those at risk of falling on welfare if they don't get their child support. And the purpose of protecting those with child support services who are on welfare is cost recovery. If the mom and their child were getting $500 a month from the government wanted to go after those dads to get that $500 to reimburse the public fisc. Then they also, so that's cost recovery. Then the second limited class of citizens for Title IV-D was the non-welfare group, which was those at risk of falling on welfare if they don't get their public assistance, which is cost avoidance. Very clear. The source I have at the bottom of this page is the General Accounting Office, but the sources go on so far, it's abundantly clear. I'm going to show you some ad nauseum, and you're going to wish I didn't give you so many here. But I wanted to let you know that that has always been the goal. It's never changed, and there's huge support for it. This is from a Washington state case law where they clearly articulated that the 4D program was for those receiving public assistance and those where there would be a real possibility that the custodial parent would fall on the welfare rolls. The Supreme Court of South Carolina also came with another case and said the same thing. For 4D services, the applicant must be eligible for 4D or for AFDC, if not likely to need public welfare if the support is not made. Just more evidence of what I'm saying is true. So I've given you three sources here about the intent and purpose of Title IV-D. And we have, as I said, many other sources. If those aren't good enough and you want more, let me know. We'll give them to you. So if those are the limitations of the program, cost recovery and cost avoidance, that is legitimate use of the program. We're totally in favor of that. We don't want to do anything to change that purpose. We believe that that's valid. There's a compelling state interest, there's a protectable interest, there's a pecuniary interest that affects your pocketbook and my pocketbook, whether it's the state pocketbook on the left or the federal pocketbook on the right. In our Minnesota statute, it's very clear that all of our 4D laws must follow the federal law. So federal 4D law actually supersedes state 4D law because we're only doing our law to implement the federal law. Right in our code, it's very clear that everything in 4D is done under Title IV-D of the Social Security Act. So the controlling authorities for Title IV-D are very clear and easy to find. Thank goodness for the internet. We can do gobs of research that way. With the state constitution and the U.S. Constitution always being the borders for everything that we do, Title IV-D law is clear with the actual law itself. And in 42 U.S.C., the Chapter 42 of the U.S. Code is where you find all of the 4D law. Chapter 45, the federal regulations, you've got state law, administrative rules, and then agency policies too. So we've been able to track all those things to try to understand where's this all been, where is it at now, and what's going on. So we've got no problem, again, for using the Title IV-D program for cost recovery and cost avoidance. The next thing that you might ask is, well, that's all fine and good, but there's probably been some amendments. 30 years have gone by. What amendments have occurred? Well, our research team has studied the amendments as well. In fact, it has been said that the original Social Security Act was 12 pages long, and today, if you were to take the paperwork of all the amendments of the Social Security Act, it would reach from here to the moon. So yes, there has been amendments. We've studied the specific Title IV-D amendments going all the way back to 1974. I've tried to summarize some of them here for you today. In 1984, there were many changes in the Child Support Amendment. And one of the things that is causing confusion with what these amendments is this kind of statement here in red, that this amendment changed things. The federal government tried to change things so that the demand for equal services, so that the demand for equal services for welfare and non-welfare could be fulfilled. Okay, but what the Minnesota DHS is coming back and saying is, well, in 1984, the federal government made us provide these services to everybody, welfare and non-welfare. They changed the laws in 1984, is what the Minnesota DHS is claiming in individual sessions with you and others. Well, our research team has done the research. We've looked through the entire legislative history with all of the federal documents to figure out what was intended and what was meant. Well, it's clear on the record that the record is filled with these kinds of comments here, as from Senator Dole, that the purpose of this 1984 amendment was to place new strong emphasis on the non-welfare caseload, because when child support payments are missed or never received, that can make the difference between remaining independent of welfare or being forced back onto public assistance. So do you see how he was really referring to the at-risk group? And if you pour through the legislative history, you'll find these kinds of comments over and over and over again. There's nothing in the 1984 amendments that show that they expanded the class to include every child in the universe. Another one of our own favorite Minnesota senators, Dave Durnberger, is also on the record, and he has a similar comment. In his statements, he talks about the same thing, how women who are divorced or have had out-of-wedlock children, they cannot find work. And especially those that have been married for a while and been stay-at-home moms, that they'll be forced to public assistance if we don't help them continue to get these support payments. They'll fall on welfare again, and we don't want them to fall on welfare again. We want to decrease that dependency. I've spoke with Senator Dave Durnberger, and he supports our research and our interpretation of what has happened all along the way. So hopefully that will give you an idea of what really happened in 1984 without getting into too many details. There's lots more details I could talk about. So then we continue with the amendments. In 1996 is when Clinton came out with the Welfare Reform Act, also known as the Personal Responsibility and Work Opportunity Reconciliation Act. They mean the same thing. If you see them, they're interchangeable. In 1996, people that I've talked to have said, as I've talked about the evolution of the 4D program, they've said, well, Clinton changed everything in 1996. Didn't you know that? Well, we've done the research. Our research team went through again the legislative record to see, did anything happen in 1996 that made the 4D program required to be applied to everybody in the universe? Well, in testimony in April of 2003 in front of the House Human Services Policy Committee, a representative from the DHS, who's no longer there, said Congress made it abundantly clear in 1996 Welfare Reform Act that 4D services had to be provided for any individual who applies for application. That was the DHS testimony in a hearing in this room, maybe even. However, we've done the research and we're not able to find it, and they have not been able to provide exactly what that is. We have found instead that in 1996, Clinton's whole purpose was time-limited assistance and increasing individual responsibility. One of the things that we found as we've poured through the amendments from 1996 is just more information to support our position. For example, this is a section of the public law that's been changed and modified. What they did is there was so much confusion on what do you mean by dependent child. Do you mean dependent child dependent on the government, or do you mean dependent child under 18? So here in 1996 law, they clarified it, and they, by striking the phrase who is dependent child and adding with respect to whom assistance is being provided. So under 4A, which as I said is the MFIP, TANF, and those such programs. So we can't find it where anything changed in 1996. And believe me, we've dug and dug to try to get the research. So how has this philosophy impacted the unauthorized, what we call the unauthorized expansion of the 4D program? The biggest question is who falls in the at-risk group of 4D recipients? We talked about so far that it means those that would fall on public assistance if they didn't get their child support. And we've also said that the DHS thinks everybody must fall into that class. But I hope that we can agree on this, that Kathleen Blatz, as a divorced person, did not become at risk of falling on public assistance just because she got divorced. I hope we can agree that Susan Gertner, just because she got divorced, didn't mean that she was going to fall on public assistance. Same thing with Pat Anderson, our state auditor. Does she need Title 40 welfare services? I hope that we can agree none of those do. Also, add some more. Elisa Rockefeller Dayton, when they were divorced, did she need 4D welfare services? Did she need the government to come in and make sure that child support was received from Senator Mark Dayton? What about Michael Jackson? You know what? He's a custodial dad. He could go to the California DHS office, fill out an application for $25, and have the government go after his, ex-housekeeper who's now a maid in a hotel to get child support for him. According to the Minnesota DHS, that would be a requirement of the DHS. So we're trying to get to that at-risk group and who should be on this program. Now, the Minnesota DHS will tell you all these people. They have to provide services to all these people if they filled out an application. Well, no one's stopping anybody from filling out an application. And the DHS is saying, you know, when you say, why are you doing this? Why do you provide these services to everybody? They say, the feds make us do it. Well, you know what? Absurdities in law must be questioned. And I think we've learned that lesson from Rosa Parks. I was listening to some of the coverage on Rosa Parks, of course, over the last few weeks upon her death, and there was some recordings from her when she was booked and charged. She looked at the police officer and said, "Why are you doing this?" And he looked at her and said, "I don't know, but that's the law." It's that same sort of absurdity and that same sort of challenge that we need to have and those eyes that we need to have as we look at the Title 4D program. The United States case law is clear too, that the role of the judiciary in cases of this sort, going back to '67 when all this was going on, begins and ends with assuring that the commissioner's regulations fall within his authority to implement the congressional mandate in some reasonable manner. Well, the Supreme Court is making that decision. That also is true for legislators as well, because if the agency is carrying out a program beyond its reasonable manner, beyond congressional intent, it's time to challenge that. And the reason it needs to be challenged is there's some huge misunderstandings taking place. In December of 2004, we got a letter from Kevin Goodnow, who I'm sure he probably didn't write the letter. Somebody on his team wrote the letter. But in that letter, it says Title 4D is an entitlement program available to anyone who applies for it. So we did some research. Where is this 4D an entitlement program? In our research, we found out quite differently. I was going to bring the U.S. Code book today with me. I forgot it. But in the U.S. Code, it says clearly that Title 4A of the Social Security Act is no entitlement. There's no individual entitlement. So you would guess that if people, low-income people on need, there's no entitlement, why in 4D? It makes no logical sense that 4D would be an entitlement program. So we did some more research to find out if that theory was true. A U.S. Supreme Court case, Blessing v. Freestone, makes a very clear statement. It says that the Title 4D program was intended to benefit individual children and custodial parents, and therefore it does not intended to benefit individual children and custodial parents, and therefore it does not constitute a federal right, and far from reaching an individual entitlement to services. And it goes on to say that it does not give rise to individual rights. So for us, that made it very clear that Title 4D is not an entitlement program. But we did some more research. In that research, we found a GAO report from 1995. In that report, it's very clear. The rate at which child support services are being subsidized appear inappropriate for a population that Congress may not have originally envisioned. They're talking about the 4D program here. Also in that report, the non-AFDC child support program, many are not within the low-income population to which Congress envisioned providing child support enforcement services. The purpose of this study was to look at that program, and they found out that the program was being broadened. They had broadened the scope to what was intended. I called the GAO. I talked to the woman in charge of these programs. She told me they reported this to Congress and that they still today stand behind this report. But we didn't stop there. We kept digging. And we found a quote from Donna Shalala from the US DHHS, who said, as part of that whole Blessing Freestone lawsuit, that a guarantee of the full range of child support services for all individual cases would bankrupt 40 agencies across the country. I guess you could call her a prophet, because that is what is happening today. We've looked at 8 county budgets in the metro area on how they're paying for these 40 services. Because the federal government, the state government has to balance their budget. The federal government doesn't have to balance their budget. The state doesn't have to balance their budget like the federal government does. The counties have to balance their budget. So what we found, for example, in Hennepin County in 2002, they had to do a $5 million tax levy just to pay for this program. And I could give you details on other counties. We can search through your county for you if you want to know the information. Let me know. Then we found some more information. There's a brief written by Ken Starr when he was the U.S. Solicitor General, and there he was talking specifically about the 4D program. The 4D program was designed by Congress to save federal and state funds, what I told you before, by recovering assigned support payments from absent parents of children and families receiving AFDC benefits, and to reduce the number of welfare recipients, consistent with what I've told you. Ken Starr says this plan would be undermined if Title 4D became an entitlement program, which guaranteed specific child support and services to all individual AFDC recipients. So here he's saying that the services are not even guaranteed for AFDC. Why would they be guaranteed for non-AFDC? You've got to ask yourself that question. Then it was interesting, there was also some testimony on file to Ms. Fry, who at that time was the chief of the Office of Child Support in California, testified in front of the U.S. House Ways and Means Committee in Washington in 1997, and she was incredibly frustrated because they were coming out and revising all of these incentive programs for Title 4D. And she's like, wait a minute. You know, the proposals here for these incentives are crazy because it's encouraging states to recruit middle-class families never dependent on public assistance and never likely to be so, recruiting them in their programs to maximize federal incentives. And she went on to say that her colleagues across the country have been talking and informing her that the way to win at this system, meaning the 4D incentive system, is to recruit the middle class so that you can bring in the higher orders into the system and get more money in your state. So when people say it's all about the money, it's not so much all about the money between the mom and the dad. With regard to the 4D system, it's all about the money for the agency. The U.S. House Ways and Means Committee, in their book, acknowledged Ms. Fry's testimony, and in their Green Book, if you're familiar with the Green Book, it comes out about once every 2 to 3 years where they analyze all of the programs. They made it very clear in there that they know the 4D program may be recruiting more and more cases from the private sector, bringing them into the public sector, providing them with subsidized services, but not greatly improving overall collections. So they know this is happening. They know it's a problem. And yes, we have contacted many people in Washington about this issue as well, and will continue to do so. So I've given you many sources about what are the limitations of the program, and is it an entitlement program or not? I've given you all of the following, and we have more if you need them as well. The expansion of the 4D program is also being further it's grown out of proportion more because of some vague Minnesota law that's on the books right now. In Minnesota 518, 551, sub 9B, this statute is in there. And I'm not going to read the whole thing to you. You've got it in your handout. But the key words here are in white. This statute says, in Minnesota law right now, in all other 4D cases, the public authority, meaning the agency here, may intervene as a matter of right. Okay? Depending on how you read law and how you know about statutory construction and how you know about rules of court, that may or may not make sense to you. That phrase, public authority may intervene as a matter of right, the first thing that you need to do is look at, okay, what are the limitations of federal law? Let's first of all take that into perspective. The limitations are those on welfare and those at risk of falling on welfare. Once that assessment is made, before you make a determination if there's a matter of right, then you must look at the Minnesota Rules of Civil Procedure. Rule 2401 says that before a third party can become involved in a case, in a private case, there must be 4 things that are proven to claim, before you can claim that interest. Those things must be that the interest and the intervention must be timely. 2, there must be an interest in the property. 3, there must be a finding that the disposition in that case would impede the ability to protect, for the government to protect that interest. And 4, that the interest here of the government would not be represented by the parties. But all 4 of those things must be true. What's happening, however, is the Minnesota State 4D agency is erroneously interpreting this phrase in Minnesota law as an absolute right that they can be involved in every private case if there's an application for 4D services. What that's creating is a problem because it's bypassing the federal 4D law and it's leading to an overly broad interpretation, which is leading to an unconstitutional application of that law, and it can be perceived as being unconstitutional on its face. Some serious issues involved here with that one little phrase. So with that overreach of authority and expansion of the program, what are the process? What are the outcomes that we face? Well, first of all, you might ask yourself, how are private cases being recruited into the 4D program? How does this happen? Well, one of the first things that happens is when a private party gets divorced and they're in court, oftentimes the judge will order wage withholding in a divorce situation. In and of itself, wage withholding, income withholding is not necessarily a bad thing. But they're doing this based on some real misinterpretations. First of all, many judges will tell you that they believe wage withholding is required by federal law in every divorce and paternity case. We've looked at the record, we've done the research, that's not true. The truth is the federal law can only require wage withholding in 4D cases. Remember what I said before, that they have no jurisdiction over private domestic relations. And federal law allows good cause exemption even in 4D cases. Secondly, many judges believe that wage withholding must be done and can only be done through the 4D system. Well, the truth is that there are 3 kinds of wage withholding or income withholding. You can either do full 4D services if you want to go sign up down at the county to have them take the money out of your paycheck. 2, there's something called non-4D wage withholding only, which most people don't even know exists, where a divorced couple can get the wage withholding service, but they're not in the whole 4D program. There's also private direct deposit now. The 4D agency, the state DHS, is started to, rather than require the non-custodial dad to write their check to the state and then they resubmit a check to the custodial parent, rather than doing that, the state is working with the new banking technology and trying to use direct deposit, which is fine and good, but what that also means is 2 individuals who are divorcing can set up their own direct deposit independent of the government. They don't need the government to do that for them. So what happens? Somebody gets an order for wage withholding, so they go down to the county and they fill out a 4D application. First of all, the 4D agency doesn't tell them there's 2 kinds of wage withholding. They just shove in front of them a 13 or 16 page application, which I have here today if you want to look at it. And they say, this is what you need to fill out the services. So unbeknownst to the custodial parent filling out the application, they suddenly sign themselves into this big program they don't even know that much about. Now, the state law and the federal law do require full notice and full disclosure of everything it means to be in that program, but we can only imagine what is actually said during that application transaction, or not said. One interesting thing too, at the very end of the 40 application here in Minnesota, there's a signature clause. In that signature clause, which the applicant parent signs, one of the key things in there, and it says, I understand that the county attorney's office represents only the county and the state. The county attorney, the 40 agency, does not represent either parent, and the 40 agency does not represent the child. There's so many people, even in the 40 system, that will say, well, we're there for the children. They're not there for the children. The county attorney and the 40 agency are there to protect the government interests. If you go back to what I said before, that the 40 system is provided for those on welfare and those at risk of falling on welfare, the 40 agency there is there to protect those two interests. The money part of it. They're not there to protect anything but that. And that's what they're trying to get across in the application here. So what happens? The custodial mom, or the custodial dad goes down to fill out the 40 application, and what we find with this application is there's absolutely no eligibility standards for Title 40 welfare services. And there's not even a place on the application for the applicant's income. It's not on there. They don't even ask. They don't care. We also find with the 40 application in Minnesota, there's no disclosure of the applicant's income, which I just mentioned, which would be required for means testing. There's also no process in place to notify the other parent that says, hey, due process notice here, you're about to go on a program. You have anything to say about that? Nothing. With the 40 application process, there's also no approval process or assessment process because everybody gets in. Why would they need to assess anything? Well, you know what? You'll see later that in 45 CFR 303.2, an assessment is required. Also, there's no investigation or verification of the accuracy of the information on that application. What happens is the non-custodial parent ends up finding in court, not in court, in administrative hearing, that the hearsay provided on that application is all considered fact. That becomes a problem. And also, there's no process in place to close the file when one parent objects. And I'm not going to get into 45 U.S.C. 1301D today, but that is another limitation that goes back to 1935 when the Social Security Act started that says if either parent objects to their child being on welfare and they're willing to take over, they get to take over. That subject is for another day. What are the fiscal outcomes when all of these cases are getting into the 40 system? Well, the DHS can boast, they can come in front of the legislature, they can write to reporters, put it in the paper that they've collected record high child support through the system. They've collected $595 million in state fiscal year 2005. Then they also come back and are discouraged and say that they need tougher enforcement measures because they say there's a $1.5 billion child support debt in Minnesota. And everybody's astounded, thinking that's horrible. You know, all dads are deadbeats. Well, wait a minute there. The truth is that $1.5 billion worth of child support debt includes 30 years worth of debt with compounded interest, and that debt includes all debt that they have reported to the finance department as written off. But they still like to talk about the big debt that nobody's paying. The funding scheme gets very complicated, and that probably is another half-hour discussion. We can get into some of that in the Q&A if you want to. But basically what we're saying is because they're recruiting so many people who don't need to be in this system, who should not be in the system, who aren't supposed to be in the system based on the federal law, that the system, the 40 system, is growing on the backs of people who should not be in the program and who probably would have paid anyway. But the more people that are in the 40 system, the more money that the state agency gets from the federal government, whether it's needed or not. I could give you lots and lots of numbers, but it can glaze over an audience really fast when you start talking a lot of numbers. So I'm only going to limit myself to 3 different slides here on the numbers. If we need to get into more numbers in the Q&A, we can do that or another time. But based on the most recent report, the Minnesota DHS Child Support Performance Report, these are the statistics. Right now in the Title 4D program, only 18% of those on the program are on welfare, and 61% are former welfare recipients, and 21 are never public assistance. Now, when you just look at these reports, glaze over them, you don't think much of this. But as we've started to question this program and how are there 249,000 people in this program, that's where we figured out the expansion of the program, that everybody and anybody's getting in this program, and it's not limited to those that were intended by Congress. There's the U.S. numbers if you have any interest in there. It's kind of interesting to see those. The problem is nationwide, and that's why we've also been working with Washington, but it's going to have to be a federal and state combined effort. First of all, let's look at that former welfare class. In Minnesota, if there's 152,000 people in the 4D system, that's 61%, we've done the research to find out how many of those should really need the services. Well, remember I said no application requires the applicant's income, so they don't keep it in PRISM as far as I know. There's no way to track what is the income of these recipients, but the U.S. Commissioner of Child Support Enforcement has found a study, and she may have commissioned the study, I'm not sure, found a study that 30% of the people leaving TANF have a likelihood of coming back. So we know that not all of those would even should be in the system according to congressional intent. As we work the numbers, based on our research, we believe that the 4D caseload in Minnesota could be reduced by 56%. And that could be reduced if we take out 70% of the former public assistance and 70% of the never public assistance. Now, this is all an estimate, but no one's been able to show us that our estimates are wrong. And if we can save 56% in expenses, maybe that's money that could be used elsewhere in a time of financial need for our state. There's a lot of numbers here. The main thing that I want you to point out is the 20% and the 40%. What's interesting is in that non-PA welfare column, the total number of recipients, that includes 20% of the total recipients, but they're getting 40% of the money from that group. Because that's where the higher child support orders, when, as the U.S. House Ways and Means Committee said, they're recruiting from the middle class, even the upper middle class, to get these higher orders in the system so they flow through so that the state can say, we dispersed $589 million this year, aren't we wonderful? The problem that this overreach of authority leads to is many constitutional violations, which creates a huge liability and which is beginning to create excess litigation in the courts because this has gotten out of control and people are fed up with it. Individuals are getting educated, lawyers are getting educated. Because of the overreach of authority is creating due process violations, privacy violations, equal protection violations, fundamental rights violations, and spending powers violations. It's huge. The problem here has a potential to cost a lot of money to the government because of that unwarranted, unauthorized overreach of authority. The second question is how can the state be assured the state won't lose the entire funding for 4A and 4D services as the DHS claims and as they have stated in testimony? First of all, I want to share with you the CPR philosophy, again, based on our research. In order to protect the family, we're asking the legislators to ensure that the state law and agency policy are acting within the scope of congressional intent. We're asking that the legislators ensure the state law and agency policy are acting to ensure the constitutional protections to all parents. And we're asking the Minnesota legislators to be innovative leaders and to be on the leading edge of this inevitable change, which we believe is going to have a domino effect across the United States, because everybody is looking to be fiscally responsible. By reducing the number of applicants and recipients of 4D, by taking out the non-needy recipients, we're reducing the unnecessary government expense and increasing public aid money available to either reduce the budget as a whole or to take that money, personnel, and move it to other programs for people that are truly needy, where the programs might be in jeopardy right now. This is consistent with even what Al Gore has said, that to achieve the goal of government is to do better with less. So we're asking two things: that the Minnesota legislature consider modifying the state law to clarify eligibility standards for 4D welfare services, and to clarify the limitations of government intervention in private cases. Here's the testimony back to April of 2003. In red, there were 3 threats given to the legislator by the DHS. Those 3 threats in red were, 1, the DHS is telling the Minnesota legislature, we have to provide these services. Number 2, they're saying, if we don't provide these services, we're going to violate the state plan. And number 3, if we violate the state plan, we're going to lose $350 million. Whereas as legislators, that's hard to hear. I would be concerned if I was you too, if you thought you were going to lose $350 million. But we've done the research to find out if this is true. Where is the specific reference in the state plan? We can't find it. The DHS also says the feds make us do it. Well, based on the research, do you think that's true? One of the federal codes that the DHS will bring up to to object to our theories is 42 U.S.C. 654-482, which the 3 magic words on the end of this are the ones that are causing the most problem. In federal law, it says that they must provide the services to everybody on welfare, and then number 2 at the bottom, any other child, if an individual applies for such services with respect to the child. Okay, you look at that, and again, depending on the lessons you've gone through on statutory construction, that may or may not be clear to you. What we say is that we have looked at many controlling authorities on this statute, on this law. We've looked at the rules of statutory construction. Our research team has looked at poured through the Federal Register, poured through case law, poured through congressional intent again, to say, any other child, what does that mean? What we found is that the word other has specific meaning in the law. That if the federal government would have intended, they made 2 distinct classes. If they would have wanted to include everyone, they would have said any child, not any other child, or they would have said all children, not any other child. This also is about a 20-minute conversation, which I won't get into now, but I want you to know we've done the research and we remain confident, maybe even doubly confident, that our interpretation is right, that nothing has ever changed in the congressional record to expand the class beyond those at welfare and those at risk of being on welfare. The Minnesota DHS will also bring up one of the regulations, 45 CFR 302.33. In there, that regulation says the state plan must provide that the services established under this plan are made available to any individual. So the Minnesota DHS comes and says, see, we have to provide those services to everybody. Again, we've done the research. And based on our research, the only way that you could believe that to be true is if you believe that providing services is the same thing as making services available. I use the Walgreens example. Walgreens corporate tells all their stores, you have to make aspirin available in all your stores. It doesn't mean you have to provide aspirin to every person that walks through the door, if they haven't met the criteria that's needed for aspirin. We've also looked in the Federal Register, as I mentioned before, and there's a specific quote in the Federal Register where they attempted to make some changes in Congress with any other or other within Title IV of the medical provisions. And the Federal Register makes it very clear that the word other has very special meaning. The Minnesota DHS will also bring up 45303.2, which, by the way, all these statutes we knew about and we had researched before they brought these up. Because we're always trying to be one step ahead. We're always trying to check and double check all of our research to make sure that we are right so that we aren't purporting anything that ends up becoming wrong in the future. Well, in 303.2, they claim that they have to make these services available to everybody based on this. But what we find interesting in this particular regulation is it said that they must open a case based on an assessment. Well, guess what? Remember what I said earlier? There's no assessment process taking place at all with these applications. Plus, there is a difference between the word accept and approve. Of course, they have to provide an application to everyone or there would be discrimination issues. Of course, they have to accept a filled out application from everyone who fills one out or they would be accused of discrimination. But to approve an application is quite another thing. And as we've seen on the congressional record, you would approve an application if somebody qualified. The DHS also claims in their testimony to the legislature that they're going to lose $350 million. The way they come up with $350 million is they say they're going to lose the $200 million funding in 4A funding is what that should be, and $150 million in 4D for a total of $350 million. So we have to question ourselves, okay, nobody wants to lose that. Where is this coming from? They haven't been willing to tell us where this is coming from, so we've had to do the research ourselves to figure out what are the federal penalties. What we found is that the only way that you would lose all of your funding for both programs is if you didn't have a 4D program at all. We're not saying get rid of the 4D program. We're just saying bring it back into compliance with congressional intent. Well, then we look at the penalty statutes at the federal level. If it would be wrong to have eligibility standards for 4D, then this is the process that would take place for penalties. It's a 6-step process, according to the federal government. If they find you in violation through an audit, step 1, then step 2, they have to decide if you are not in substantial compliance, because the federal law only requires the state to provide services in 75% of the cases they receive an application for. Who's ever told you that? Then, if they find you not in compliance, the federal government would give the state a whole year corrective action period to say, shape up, change things, don't do this anymore. A whole year. Then after a whole year, if the state had not made those changes, then there would only be a 1 to 2% reduction in the 4A funding. Third year, 2 to 3% reduction in funding. Fourth year, 3 to 5% reduction in 4A funding. Nowhere does it say if they're in violation of the state plan, they're going to lose everything. So we've tried to work with the numbers here. And according to our numbers, if we're saying that the federal government would never come after the state if we implemented eligibility standards for this program, but if they did, the maximum penalty would be $10 million. We're saying that the state can save $100 million a year by removing the unqualified class out of the program. So if you take $100 million minus $10 million penalty at the most, you're still saving $90 million. We say that's worth looking at. We've also done research across the country and looked at many, many states, and we found that if California were to implement eligibility standards, that they would save $1 billion, and nationwide we could save $88 billion by bringing this program back into compliance with congressional intent. Those are the 2 questions we've reviewed today. Does the federal government allow the state to initiate reform? And will the state lose $350 million if they do so? I like this quote from President Coolidge. Of all forms of government, those administered by agencies are about the least satisfactory. Being irresponsible, they become autocratic. Being autocratic, they resist improvement and change. Unless bureaucracy is constantly resisted, it breaks down representative government and overwhelms democracy. It is the one element in our institutions that set up the pretense of having authority over everybody and being responsible to nobody. We are forcing that responsibility of the 4D program and hope that we can work together with you to figure out fiscally responsible decisions that can be made to put this program back into compliance. And with that, I'm ending about 10 minutes early, so we have plenty of time for questions.
CPR serves parents and children with research, education, advocacy, and support.
Since 2003, CPR has grown steadily through the generous donations of both time and money of strongly committed volunteers.
Now we need your help.
Take time now to support CPR with a financial contribution.
Please give generously. You'll be glad you did.
CPR is a 501c3 nonprofit organization, so your donation is fully tax deductible.
Your contribution will make a big difference. Every amount counts. Thank you for your support.